How do I find the right lawyer? In this video series, I will answer this question by answering 7 constituent questions.
This is Christian attorney Ariel Johnson, lawforlife.us. The purpose of this channel is to make the law accessible to real people. So if you find the information in this video helpful, please subscribe and share it with other individuals. Also, I want to thank everyone who has subscribed to the channel thus far. Please feel free to send me questions or make suggestions about other videos that you'd like to see us do. Now on to the topic of this video. Question number 4, how do attorneys set their fees? Well, there are a number of different fee models, and I'll cover those momentarily, but I think it's important to start with the question of what do the model rules say about attorney fees? Well, paragraph 9 of the preamble to the model rules astutely points out that virtually all difficult ethical problems arise from the conflict between a lawyer's responsibility to clients, to the legal system, and to the lawyer's own interest in remaining an ethical person while earning a satisfactory living. In other words, lawyers want to be paid first for their work, but at the same time they have a duty to zealously represent the client, and lawyers know once they accept your undertaking, they are required to see it through to completion. But the problem arises sometimes when a lawyer has accepted a client's case, which may last a year or more, during which time the lawyer is going to accrue fees, submit invoices to the client, and expect to be paid. Well, every now and then a client is unable to pay an invoice on time, which prompts many lawyers to want to withdraw from the litigation and can oftentimes put the lawyer at odds with the client in either a billing dispute or in the lawyer's request for permission to withdraw from the case. And therein lies the ethical challenge lawyers face and clients face with regard to payment. Consequently, Rule 1.5 governing fees tells us that a lawyer shall not make an arrangement for, charge, or collect an unreasonable fee or an unreasonable amount for expenses. And reasonable fees are determined by 8 different factors according to Rule 1.5. The first consideration is the time and labor required, and also the novelty and difficulty of the questions involved in your case. Also part of this is the skill necessary to perform the legal service properly. For example, many lawsuits require intricate, if not intimate, knowledge of a particular field which may be outside of the law itself. For example, if you're having a dispute with a builder or a contractor, understanding different principles of engineering or building code standards requires a specific and definite skill set which might be foreign to most lawyers, but if you have a lawyer who specializes in those type of lawsuits, well, that lawyer is in a better position to charge a higher fee than other lawyers who may not be similarly situated in terms of that area of specialized knowledge. The second consideration in setting a fee is whether or not the lawyer is turning down work in order to accept your case. Third is the customary fee charged in the locality, and many state bars are interested in what lawyers are charging, so they typically keep a list of what large law firms are charging per hour, what medium-sized law firms are charging per hour, and what solo practitioners are charging on an hourly basis. So if you want to find out what the average hourly fee is for the type of lawyer that you are planning to hire, the state bar probably has that number for you. The fourth consideration that the model rules contemplate in determining whether or not a fee is reasonable or not is the amount of money involved and the results obtained. Primarily, this consideration goes to cases in which there is a contingency fee involved. And those are usually slip and fall accidents, auto accidents, where there is great bodily injury to the client, enormous amounts of money involved in the client's claim for relief, and an inability of the client to pay the necessary fees up front. I'll cover the contingency fee model momentarily, but the idea that the client does not pay the lawyer anything up front, and as a matter of fact, may not be responsible for any fee unless the lawyer is successful in the litigation. The fifth consideration is the time limitation imposed by the client or by the circumstances. So if you are required to obtain a lawyer, let's say to answer a complaint that's been filed against you, and the lawyer only has a week to answer that complaint before the time to answer that complaint has run, you're requiring that lawyer to possibly put in numerous hours in a short period of time, in which case the fee charge may be affected. The sixth consideration is the nature and the length of the relationship the client has with the attorney. For example, if you're a business who routinely gives that lawyer work, that lawyer may negotiate or have an arrangement with that business that they pay a reduced fee in contemplation of additional work to come in the future. Number 7 is the experience, reputation, and the ability of the lawyer in performing his or her duties. So in other words, if you hire someone who's considered a legal star, and almost everyone who hires that person expects and has in fact paid that person a great deal of money, then that lawyer can reasonably expect that if you want to hire that person, that you will also pay that amount of money. And finally, whether or not a fee that a lawyer charges is reasonable or not is determined in part by whether or not that fee is fixed or is contingent on the outcome. So now let's talk about some of the different fee models. The first fee model is the hourly rate. And the important thing to know about the hourly rate is that the hourly rate is not just what you pay for a full 60 minutes. It's what you also pay for every portion of that 60 minutes. So if your attorney is charging you $200 an hour and they expend 15 minutes on your case, then you can expect to get a bill for $50 for that 15 minutes. You should also know that if in most attorneys' billing models, instead of spending 15 minutes on your case, the attorney spends 16 minutes, you may be surprised to find that that attorney is going to charge you $100 because the time spent bled into the second quarter of the hour. But the important thing to know about attorney fees is that the rules require that the fee being charged be explained to you in writing, usually in a retainer agreement. And if in fact the attorney is going to charge you for a portion of an hour, that fact should be spelled out in the written fee agreement. The second is a flat fee, and flat fees where available are generally better than hourly rates because a flat fee is a prearranged amount that you pay up front to have a particular job done. And that job is also generally limited in scope. So you may pay someone to simply file a quitclaim deed for you, or you may pay someone to draft an order that you need in a case in which you're representing yourself. And the flat fee is paid for a defined amount of work, and it limits the scope of what that attorney is doing for you. Next are cap fees. A cap fee is an agreement with the client where the client agrees to pay the attorney's hourly rate, but the number of hours for which the attorney may bill is capped at a predetermined limit. So you may hire someone that's charging $300 an hour for their legal services, but your agreement specifically caps the agreement at 10 hours of work. So the contract on its own terms prohibits the attorney from billing you for more than for that 10 hours. Next is the retainer agreement. The retainer is a lump sum paid up front from which the attorney deducts his or her hourly fees. Fifth is the contingency fee, and this is the fee structure that I mentioned earlier in talking about Model Rule 1.5. And a contingency fee is a contractual agreement almost always required by the state bar governing attorney practice to be in writing, wherein the attorney and the client agree that the attorney takes a certain percentage, usually between 30 and 40%, of any monetary settlement or damage award that you may receive. Now, the important thing to remember about contingency agreements is that 30 to 40% contingency fee, which is only paid if the attorney wins or is successful in your case, or is able to reach a successful settlement with the other side, is separate and apart from any expenses that the attorney may have. For example, if court reporters have to be hired for a deposition in your case, those deposition fees are usually paid up front or advanced by the law firm, but at the conclusion of your lawsuit, the law firm is going to recoup those deposition fees from your award. So if you have an award of $100,000 and the attorney is entitled pursuant to the contingency fee agreement to $30,000 or $40,000, if you have deposition fees, copying and mailing fees, fees associated with process servers, or other professionals who may have been retained in order to get you to the conclusion of your case and to that judgment, those fees are going to be assessed at the end of your lawsuit, in addition to the attorney's contingent fee. Next are unbundled fees. Earlier I talked about unbundled services where you pay an attorney for a specific task and the representation is limited to that task. And those tasks include things like drafting documents for you, perhaps helping you negotiate a settlement, or it may just be in helping you evaluate the strengths and weaknesses of your case. Whatever that unbundled service is, you're paying for that specific task. And when you find an attorney who's willing to unbundle services for you, clearly the fee you pay for that unbundled service is going to be a fraction of what you would pay if you retain that attorney through any of the other means mentioned above. Next are sliding fees, and sliding fees are pricing models based on the client's ability to pay. And they're often determined by income and or family size as taken from the federal poverty guidelines. A lot of law clinics and nonprofit legal firms employ sliding fees, and sometimes entities connected with courts that provide low-cost legal services will also employ a sliding fee model, and they can do this sometimes because they have grants from grant-making entities or because they have a nonprofit legal firm with an earned income strategy that allows them to extend a sliding fee to their clients. Finally, you have per diem, and per diem, of course, means per day, and a per diem arrangement is an arrangement whereby the client agrees to pay the attorney an allowance in lieu of paying the attorney's actual fees and costs. Now again, the only rules that govern whether or not a fee is reasonable is the rule that I outlined, and that is Rule 1.5. However, you have the option of shopping around and talking to other lawyers, but again, I would caution people about looking for the lowest price lawyer and simply advise you that at some point you're going to reach a median number for the area of law in which you need representation. But again, price should not be your primary consideration. Your primary considerations should be whether or not that person is ethical, whether they're wise, whether they're empathetic, whether they're committed to you in your case, and whether or not they're competent. The other determining factor of whether or not a fee is reasonable is when, let's say you're successful in your lawsuit and you and your attorney ask the judge to award reasonable fees and costs to you as a result of having won your lawsuit. Or occasionally when the other side has been uncivil and is engaged in behavior that has offended the court, and as a result the judge has sanctioned the other side, and at the end of that process your attorney is asked to submit a bill of costs to the court, which includes of course that attorney's fees, which you have probably already advanced. Well, in that endeavor what happens is that the judge will be the arbiter of what's a reasonable expense and what's a reasonable cost in making his or her award to you as a result of either a statute that provides that you are entitled to reasonable attorney fees, as a result of a finding by the court that the other side has behaved inappropriately, or as a result of a contract dispute in which you are victorious and the contract provides that loser pays winner's reasonable attorney fees. In any of these circumstances, the judge is going to be the final arbiter of what is a reasonable fee, and not you, your attorney, or the other side's attorney. It'll be the judge who makes that determination of what's reasonable and what's not reasonable. Well, that's it for this video. If you find this video helpful in any way, please share it with others. Also, consider subscribing to the channel so that you can be notified when we produce new videos. As I've indicated before, the purpose of this channel is to make the law accessible to real people and not just the exclusive province of attorneys.
Thank you for watching. We profess the truth that we can do nothing without God. God bless.